Hi guys, welcome back to Bat of Itola. This is Mojola Olua and I'm super thrilled to be here once again. As always, of course. Thank you so much to everyone that has been a part of this journey. It's been well over 4 years and we're grateful to God for what He has helped us to achieve so far. We're grateful to every viewer, every sharer, every liker, every commenter, every listener. Thank you so much. This is going to be a very long video. You know that when I say very long, it's relative. Some people might not consider it long, some might, but that's just a caveat. Today we want to talk about client counseling and interview, or client interview and counseling. It's a very important topic in law. Now, it's important for law students because it's a old topic. I think it's a whole class on its own at the Nigerian Law School. In the Nigerian Law School syllabus. It is also important for lawyers, practicing lawyers, could be a refresher course. It is also important for laymen, so that when you go to a lawyer's office or when you require the services of a lawyer, you know what to expect at the client interview and counseling stage. Now, it is even more important for lawyers who are starting their own practice. Usually, when you start out as a lawyer in Nigeria, you most likely, it's no longer the general practice, but back in the day and still now in some instances, you'll be attached to a law firm, to a senior lawyer, to a principal. You work with the person for a few years before you start out on your own. I have a law firm of my own, but before I started out, I worked with a few law firms and some principals. So usually it could be, or maybe, or the case would be that you would not even get to interface with the client in most cases until you meet them in court, or until you have to go to court on their behalf. It's your principal, your senior, that will do the counseling and interview, the charging, the billing, and everything. And most likely you just be preparing the documents and be going to court. So when you start out on your own, it could be quite challenging, for you to figure it out. How do you talk to clients? How do you start out? How do you interview clients? How do you counsel clients? So that's what we want to discuss in this video. Sit tight and bring a friend along to Battle with Ola. Client counseling, or client interview and counseling, it's a very crucial stage in a lawyer's relations with the client. It is that stage where you elicit information from the client to help you understand the legal challenge and to propose solutions. It is the stage where essentially that's the starting point when a client is engaging your services as a lawyer. They tell you what the problem is, then you tell them what the solution is. But there's a lot that goes into it. It is not as simple, as basic as we have just said, A to B. No, between point A and point B, there's so much involved. So let's start with interview. I like to start with interview because you interview the client before you counsel them. That's standard procedure. That's what we're taught in law school. You don't put the cart before the horse, except you are telling the client, you don't really need me, or let's just go right into you, go and do this for yourself, or you're not interested in pay as a lawyer. So interview, what happens in the stage of interview? Usually the client books an appointment, if that's how you run your law firm, which is how I run mine. You book a paid consultation online for those who have been beneficiaries of this channel. And we've had a sizable number of people come from our Batok family. Thank you so much. You know that's how it works. You book a paid consultation slot, you choose your time, your slot, and all that. For those who do who run physical law firms, their clients will walk into their office, ask to see a lawyer, most likely talk to their secretary first, or they might also be booking. Physical offices can also run by booking. So whichever the case, the client has booked a slot. Now they've come into your office to see you. How do you start? The first thing is to make them comfortable. Now, if you're a law student and you're at the Nigerian Law School, whatever your lecturers teach you is the final verdict for the purpose of bar finals, but this is the practical, the real life experience. I'm infusing my own experience, what I've seen and what I've experienced, what has happened to me, how I've conducted my own interview and counseling into this video. So just merge the two together, but know that your lecturer's word is law. So they have come into your law firm, you welcome them, make them feel at home. So that should be the starting point, but I'm assuming that would have happened, with your secretary or as the case may be. But if you're running a virtual law firm, because this is what I have to do myself, or if just to make sure, even if your secretary has done the preliminaries, you make them welcome. Oh, you will welcome you to OM Livingstone & Co. This is a law firm that caters to so and so. We have branches in so and so. This is our expertise. We are ready to provide the legal services that you may require. Welcome. Make them feel at home generally. Some lawyers, senior lawyers, they know how to crack dry jokes and make small talk. You could also do that. Or maybe the person has come in a rainy season. Maybe it had just stopped raining. Oh, hope the rain did not beat you. If you're Nigerian, that's how we ask. Hope the rain did not beat you. Or hope you didn't catch a cold. Or maybe it's not your law firm is not in a conspicuous place. Hope you didn't have difficulty, finding your way here. How's the weather? Is the atmosphere okay for you? Especially if it's hot now, you could say that. Oh, maybe you don't have your AC on because you were feeling cold. You could say, should we turn on the AC? Just make them feel welcome and at home. You could offer them drinks or whatever you offer your guests, and then you explain to them, you take them through your expertise, possibly your experience if the case warrants. Because I used to be a mediator, I'm still a mediator, but I practice mediation, as the mainstay of my practice for 3 years at a government mediation house, where I was also a prosecutor. We talked about that extensively, almost to the point of being tried on this channel. I even wrote a book on it. Please buy it, look for it in the description box. So when I'm starting my mediation sessions, I have to do what is called the introductory speech. So usually it was easy for me to just translate it into my law practice. So it's easier. All you need to do is tell them why they are here, what you do, the services you render, how their need may be met by those services. You could tell them what you've done in the past, tell them your capacity, your expertise, whatnot. Then the next thing is to ask them, why are you here today? How may we be of help to you? What's the legal challenge? So you allow them to talk. So you start by allowing them, you continue by allowing them to talk. Then they will narrate the solution, the challenge to you. Or maybe they were robbed and they suspect their neighbor, or maybe they were defamed. Someone has published some defamatory things, some abusive language online. Let's use layman term, and then they want to punish the person. They're angry. So, okay, what are those? What really happened? So allow them to tell the story, but guide them with your questioning. So we'll tag that active listening. Active listening is the stage where you listen to what they have to say, but you take them through with, connectors and open-ended questions. So what happened after then? Are you saying that this happened? When did that happen? How did it happen? Who is this person? What's the name of that place? Really, all kinds of question tags. Not to put words in their mouth, but to help them bring out the things that they would otherwise not have even said, because they do not know that it's an important part of the information. So active listening, very important. So after when you listen to them, you also question them, which is what you have said. Question them to elicit more information. Someone says that someone has insulted them online. You need to ask background information. Do you know them before? Have you had any business with them before? What really led to this? Is this person, do they usually just go about insulting people, or is your own case just a peculiar case? Is there any truth to what they have said? Questions, you ask questions, and then from questioning, you then begin to look at, you're actively in your own mind as a lawyer. You're already thinking of the solutions. Traditionally in Nigeria, what people would do, walk into a lawyer's firm. In fact, some people will just call their friend, who will just call one auntie that is a lawyer, one uncle. They will do the interview, the counseling for free. And then when it's time to now take action, they will now decide if they want to pay the lawyer to take further action or not. But in cases where you don't need further action, that means you've enjoyed a free service and the lawyer has provided his services for free. I know that many practices are moving away from that, and that's no longer the situation. Thankfully too, there's been, a mass exodus of Nigerians into other jurisdictions who have seen how it is being done, and they now appreciate the value of the time a lawyer spends to interview and counsel them better. So now I'm laying this foundation to help you understand as a lawyer that at the counseling stage, you've done the interview now. It's as simple as that anyway, by interview. So for the counseling stage, what you need to do is not tell them what you would do as a lawyer, what the steps you would take for them if you had been paid, but just generally counsel on what the situation requires, what the legal options are, without putting too much on the table, such that if they walk away, you are not cheated and you have not harmed them or harmed the lawyer they might go to with the tools that they would use for free. But if you have been paid for a consultation, which is interview and counseling combined, which is the modern day practice, which is what we do at House of O.M. Livingstones and Co., you can go ahead and lay all the cards on the table, tell them what their legal solutions are and how you would apply it if you were their lawyer, and then they can decide if to go on. If they are going on, fine. If they are not, you've been paid. So that's something that several years ago when I was at the Nigerian Law School, the lecturer made clear to us, and I've seen it work out in practice. So I am always remembering what she said and why she said it at the time. It's been a long time ago. Things have evolved, but some practices are still affected by this syndrome of people getting free counsel and then going away to implement it themselves or detail another lawyer to do it for them without paying a dime to the lawyer that counseled them. So a lawyer must be smart. Now, counseling stage, what do you do in the counseling stage? The counseling stage is the stage where you then tell them their legal options. Now, we are using a defamation case, for instance. They think it's an insult and they want to punish. So what do you say? Okay, this that the person has said, from what I've asked you, it seems as if it is true. So it will not come as news to anyone. And if anyone hears it, it will not reduce your value or your honor or your prestige in their favor, in their eyes or in their mind. So it really will not pass for defamation in the court of law. We've told them that. Then this that they said is unfounded and they sound very factual. So we must put them to the test to defend this in the court of law. So these ones are defamatory, these ones are not. So this one will fly, this one will not fly. Now there's criminal defamation in Nigeria. There's civil defamation. You can take out a civil lawsuit against them, or we can go the criminal way by filing a complaint with the Nigerian police, who would then take it up. So if it is online also, you can also come under the Cybersecurity Act to get redress. So you tell them those options, then you tell them what your charges may be. This will cost you so and so. It will take a certain length of time. You tell them the time frame. You tell them the things that are involved. We need to go to this police station. We need to file at this law court. It's better to file in this jurisdiction than this jurisdiction. This is the appropriate court to go to. These are the evidence, the pieces of evidence that we will need. You need to give us this, and that. Do you have this? Do you have a printout? Is it time stamped? Is it this? Is it that? You have to elicit all of that from them. Then tell them what you would do, how you would do it, when you would do it, the time frame it might require to get them the justice that they require, and every other thing, the whole works. And then you give them the opportunity to make a decision if they want to proceed with a suit or with the next step, maybe filing a petition or not. So that's essentially client interview and counseling. Now we're going to look at some of the features in greater detail. We talked about active listening. These are some of the things that can help you listen to your client actively. Pay attention to the client's needs. If it's a client that has come into your office and is illiterate, for instance, or uneducated, unlearned, you can choose to speak in a language that they understand. Maybe they can't even speak English or express themselves well. You can switch to Pidgin as a lawyer. It is important to make your client feel at ease. So you can switch to Pidgin, you can switch to Yoruba, you can switch to Hausa or Igbo or whatever language your client misspeak, then you can also use the colloquial parlance that they would easily relate to if it is within your capacity to do so. Make them feel at home. Don't be condescending. Don't use grandiose terms. Don't be on a high horse looking down on your client that yes, so what happened? For instance, if your client is saying that somebody insulted them, you say, oh, you mean they defamed you? That's not the first thing to do. The first thing is to let them state the insult, what it is, why, when, how it happened, everything. It is when you get to the counseling stage that you then let them know that in law, what you have described is defamation. In law, what you have described is not defamation, as the case may be. So pay attention to the needs of your client. If your client is a younger person, you need to know how to relate to them, maybe in en vogue parlance, and colloquials. If your client is an older person, you know how to defer to them. If, for instance, you have a first name policy in your law firm and a client that is 82 years old walks into your office or books a consultation, you cannot just say, yes, Tade, what are you saying? No, you need to say, yes, Mr. Tade, oh, Engineer Tade, or should I call you Dr. Tade? What would you like to go by? You accord them the respect or the deference, not even respect now, because most times in Nigeria especially, what we call respect is not really respect. So you accord them the deference that comes with that age, and that caliber. If your client is a person of means, they may come in expecting to be treated a certain way. So please move up to their level. If your client also is a person of lowly estate, they may be afraid if maybe it's a big law firm or a shiny outfit you have, or they may be concerned about not being treated properly. You need to let them know that we treat all clients' needs equally here. The important thing is to get you the most fitting legal redress, not to crucify you because of your estate. So when it comes to payment, you will know how to reconcile their pocket ability to what you can do. But at the counseling and interview stage, treat your client with utmost regard and utmost deference. So we've talked about understanding the need of your client. It's also important to ask open-ended questions. Don't shut your client out. So you ask questions that help your client talk more. Remember when we talked about examination in chief on this channel? Watch that video if you have not watched it. It's a very important video. So in examination in chief, we talked about how you should ask open-ended questions to help your client tell the story. So if that's the first time you're meeting them, you need to let them tell the story. Even if you have discussed some things informally before, this one is for record purposes. You must elicit all the information they need. For instance, if your client is saying that their boss fired them, you don't just run to town and say, oh, that's wrongful determination. We're going to file a lawsuit for wrongful termination. Ask them all the questions. What happened? When did this happen? You said that they started shutting you out of meetings. When did that start? What did you do? Did you have any altercation with this person? Why is this particular person featuring in your story this much? What's their relation to you in the company? You ask open-ended questions to elicit all necessary information. Now, very important for you to have a notepad and a pen to jot things down. Don't commit things to memory all the time. Make sure you jot things down. At our law firm, which is a virtual firm, we have this tradition of sending our clients a recap by email of everything we discussed during their consultation session. We talk about the facts that they stated, the solutions that we preferred, and the action points that they went away with to do or to employ our services or the services of a lawyer to do further. So very important, and clients appreciate this all the time. So how would you do that if you're not jotting? Make sure you're writing things down. Make sure you're not making a book or a thesis. The important things, names, dates, action points, legal opinion and the legal rules that apply, and the facts of the matter. Make sure you're jotting things down. If you could also, if you're doing a virtual interview and counseling session, you could also, this has already been overtaken by the event that we've described, but if you're not doing it in this pattern, you could also have like a Google form or some kind of form, maybe physical form. It could be a physical form if you are in a physical form, or an e-form that the client can fill with the most important details pertaining to the area of law where they seek help. That could also help you develop the basis, for a future case or further steps to be taken. Very important. Then avoid making assumptions and avoid interactions. If a client has come to you for a dissolution, maybe they want to leave their marriage, and they start talking about how maybe their husband does not listen to them, is not meeting their needs, maybe he has deserted them or anything. Don't assume and say that, well, women, that's how women are. Many Nigerian men say things like that. As a lawyer, distinguish yourself. You can be saying that, it's not even proper, but if you want to say it in your banter with your friends outside, not with a client. So you don't shut a client out by saying, oh, that's how women are. Even my wife that is at home, she's this, she's that, she's this. No. Don't make assumptions. If someone has come to you and they're of a particular tribe, and maybe there's like a stereotype attached to that tribe, don't bring it out in your client interview and say, that's how people from that state, that's how they all behave. No, that is not for you. This is a process of eliciting facts, helping the client apply what the law says, and deciding how to go further, not for you to make assumptions. And don't interrupt your clients too much. Sometimes if you interrupt clients, they lose their train of thought. And, because at this stage, you are relying on them, for the foundation of the case, whether it's going to be a litigation or solicitor work. Even if you're going to just draft a land agreement for them, you need the information that they're going to put. Even if you're going to draft a land agreement for them, you need the basic information that they would provide from their own knowledge, because at that stage, those things are facts outside of your knowledge as a legal practitioner. So don't interrupt the client too much. Let them speak. Let them say what they have to say, and elicit all the necessary information before you make assumptions and before you round off the session. So don't interrupt your clients too much. Also, it's important to empathize with the client. If a client is narrating something and they're shedding tears, that's not the point for you to say, yeah, let's be fast. Oh, your time is running out, you only booked 30 minutes. No, empathize with them. Give them a tissue if it's physical. Say some soothing words, and or give them, a little time to get themselves back together. Empathize with your client. Create a safe environment. Let them know that what they're discussing, there's confidentiality. It's just you and them, or you and them, and if maybe your associate or whoever you're interviewing them with, let them know that whatever they discuss with you stays with you, stays in that room, stays within their engagement with you, not that you will go and blast it on the rooftops. It's important to make your client feel safe and welcome. Then another thing is to be clear in your communication with the client. Explain legal jargons to them. For instance, in a defamation case, you could let them know that, this is defamation. Under the law says that this and that constitutes defamation, and these are the ingredients. This is what we need to prove. This is how we need to prove it. That's when you've moved to counseling stage. Very important. Don't just throw legal jargons into the fray, because most times clients are impressed actually with lawyers that speak legal jargon, but then they will go not even understanding anything. Maybe someone has come to you now and they need to adopt a child for you to file the adoption process, and you've used so many legal jargon. They're impressed, but they get them, they tell their spouse, so I went to see a lawyer today, said this and that, and maybe their spouse is then angry, or then start having reservations that, what does it mean by we are going to do this? I don't want to do that, because you were not clear. Very important. Break down legal jargon into clear, concise, and understandable format for your client. Very important. Also, answer questions honestly and simply. Don't be grandiose. Answer questions honestly. For instance, I find that most clients want to know for me as a Nigerian lawyer, they want to know if we actually do this, will we really get results, as per, let's leave law now, in practice, in real life, will we get results? Do you think that the police will not compromise? Do you think that if we go to EFCC, they would not compromise this matter? Or, okay, we want to file for letters, want to obtain letters of administration. How long will it take in real life? Even though we've checked the website of the state agency or the probate registry, they said it's 21 days. Is it really 21 days, lawyer? So they ask a lot of questions about the actual, way that things might go. It's important for you to answer honestly. I found in my practice that honesty is very important, because when you now start the process and the things that you foretold are happening, you have rest of mind that I've kukuma given them caveats that this is Nigeria, this is how it works, this is how it may go. So not that you overpromise and then underdeliver, because sometimes the underdelivering may be outside of your capacity. It may not be, you may be trying to do well, but it may be without your power. So please answer questions honestly at the counseling and interview stage. Very important. Also discuss potential outcomes. I think I've mentioned that, and the risks, or if you're taking, for instance, if someone has come for a dissolution matter and there's adultery, or if you want to file for adultery, you have to join the co-adulterer. That's the person that your wife or your husband is seeing outside of the marriage. You have to have proof, you have to file this also proof. Are you ready to do that? You let them know what they might need to do and what it might come to. Or if you're filing this matter in court, you will need to give evidence publicly and say all these things before the court and probably a court audience. Are you willing to do that? This and this, so that in future they will not come and say, lawyer, you didn't tell us this, so we didn't sign up for this. This is not how we thought. No. Very important for you to discuss potential risks, potential outcomes. So if you want to write to your boss for so and so, he's going to get angry. This may lead to you getting fired. Are you ready for that? If you're asking us to write a letter to your landlord for so and so things, they may get angry. They may try to evict you. Discuss potential outcomes and risks. Also, we've talked about confidentiality. Very important. Let your clients know. And confidentiality is not only in assuring them that what you say or what you discuss with them, what they discuss with you, will be safe and secret. It is also shown or demonstrated in how you talk about other clients. So when you say things like, Chief Labaja was here last week, we told him this and that. Dr. So-and-so was our client in 2020. He wanted to divorce his wife. He had so-and-so STD. So no, you cannot give out the information of other clients, because confidentiality is not just in what you don't do, but also in what you do. So if you are, it's important actually to make reference to cases you have done and clients briefs you have handled, which apply or which are similar to the one before you, just to help your client understand that this is your expertise, and to help them know that they are not the only ones this is happening to, and to help them know that there's redress. Because if we help so and so get redress, we can help you get redress. But what I'm saying is, don't disclose too much information, and don't disclose biodata or anything that can help them deduce that he's talking to me about this, or she's talking to me about this person or that business. I had a client once who wanted to, in fact, not just a client, a good number of Nigerians abroad, they appreciate the issue of confidentiality a lot. So even when they are paid for a consultation and they're discussing issues with you, they keep some things secret, because they don't know yet if you are the kind of lawyer that would expose them, or if you have a connection to the person they have an issue with, such that you may compromise their situation. The client wants that when she sent me documents upon documents, she redacted a lot of things. I didn't care, because I didn't even need those things to advise her properly and to help her prepare the documents that she needed. And then when we were done, she was so grateful. She even told me about another legal service that she tried to use before me, and what had happened and all of that. I had another client that wanted to discuss, property, in Nigeria, and she withheld a lot of information until much later on the call, when she now said, oh, let me just tell you, this is what I'm talking about, this and that. At that time, she was already certain that, oh, this person knows what she's talking about and maybe she can handle this information. So it's important for you as a lawyer to help your clients feel safe and confident in the information that they're sharing with you, or that you're sharing, or that you're exchanging. Very important. Another thing is being staying ahead of the curve as far as legal knowledge is concerned, and owning up where the knowledge is inadequate. So if you're operating a booking system, you should create, a way for your clients to inform you or give you a hint about what they're coming to discuss, and then you can research on that before they come. But even if not, Lord Denning said, God forbid that the lawyer knows all the law, but that he knows where to find the law. So even if they're telling you or discussing something that you're not very abreast of or very well aware of, or that's not really your expertise or area of knowledge, you can honestly and sincerely own up and promise to look into it. I had a client once that had booked outside of Nigeria, and she was presenting a case. The course of action was outside Nigeria. I let her know at the beginning that I'm a Nigerian lawyer. My expertise is Nigerian law for now. So when we now got to that point, I told her, I said, my expertise is Nigerian law. She said, don't worry, go and do the research. I want you to handle this matter for me. Just go and research on it. It's important for you to be honest. Don't claim what you don't know. Also, you can let your client know that we'll get back to you on that, or I'll make further consultation. I had another client that it was Nigerian law, but it was something I was not too familiar with. So you have to catch your response or your reaction in such a way that you're not telling them, oh, I don't know anything, no, because they have paid you because they believe you know. But you're letting them know that, oh, I'll make further findings on that. I have a friend who works in so I know a legal assistant who works in so I'm going to make my findings. In another matter that I handled, we had discussed up to a point that was beyond what I was familiar with. So I promised them, I said, I'm going to ask so and so person. They work in this jurisdiction, in this particular specialized court. I'm going to talk to them and let you know what they tell me, what I find out. It's as simple as that. Nobody will kill you. So it's very important for you to demonstrate honesty as regards the scope of your knowledge. Another thing is setting boundaries. Very important. When you're conducting client counseling and interview, don't crack excessive jokes such that the client will not take you serious or you get carried away. Also, let the clients know the bounds and the limits of the services they have engaged or are engaging you for. This is what you've paid for covers. This is what we do in our law firm. We will not go to this extent. We don't do this, or this is what we do. We're going to go all the way. We're going to do this, and that for you. So let them know the bounds of their engagement with you. It's also important to get a hold of your emotions as a lawyer. The client cannot be shouting and you are shouting to match them. The client cannot be angry and you are angry as well. Sometimes clients will want you to match their emotions. Maybe a woman that wants to leave her husband's house that wants to get a divorce, a file for dissolution, is so angry. She's talking about her husband and she wants you to match her energy. Like, you should be ready to even slap the man on sight. You cannot match the client's energy. Yoruba people say, that is, you cannot match the stormy sea with a stormy paddling or a stormy rowing. Very important, for you to be calm, to maintain your calmness, to get a hold of your own emotions. If a client is saying something that infuriates you, maybe they have said something about your tribe. We're an heterogeneous society in Nigeria. Or they've said something about your faith. If you're a Christian, for instance, and the client has said something that is disrespectful to your Christian faith, you don't get so emotional that you display your displeasure outright. Very important for you to get a hold on your emotions about what they're telling you about other people or how they're relating to you, because you are the expert, you are the learned person. Don't ever forget that. You are in the balance of power in that setting. You're higher on the scale. So it's important for you to treat things as such. It's also important to give alternative solutions. So if a client has come thinking to go to court for litigation and you think mediation is the best alternative, you can suggest that. So suggest a variety of options to the client so that they will choose the one that is most fitting. While you cannot force your own thinking on them, you can help them make the best choice. You remember that the rules of professional conduct encourages lawyers especially to advise their clients on the option of ADR. I've been in court. I was in court one time and the judge asked the lawyer, even called the client out and asked the client if the lawyer had advised him on the option of ADR, alternative dispute resolution. He said no. So it didn't look good for the lawyer. So it's important, if your client wants to go to court and you think that ADR can settle this matter, advise them. And if they want to do ADR, if they want to mediate, for instance, if a client wants to mediate a rape matter or a robbery matter, and you believe that no, this is going to boomerang, this is not good, this does not do justice, it's better to litigate, to prosecute, advise them properly. If a client also wants to go the dissolution way and they want to fight it to finish, and you think that maybe you can mediate between them and their spouse, maybe to reach some agreement on child custody, child maintenance, spousal maintenance, and all that, so that you would then present that to the court as alongside the prayer for dissolution as terms of settlement to be adopted, you can advise them as such. You cannot change or twist or untwist your client's will or mind, or person to do what you want, but you must advise them as best. We've talked about a lot of things. We talked about active listening, empathy, confidentiality. We talked about not over-promising and under-delivering, setting boundaries and helping clients understand the limits of their engagement with you. Talked about helping clients trust you, being professional, making them welcome, empathizing with them, respecting, deferring to them, emotional intelligence, cultural awareness, and a host of other things, which I hope you have been able to deduce in this video. So this is what we call client interview and counseling. Eliciting information from your client, advising them on their legal options, and helping them arrive at the most fitting legal solutions. I hope you have learned a lot in this session. I will see you in my very next video. Don't forget to subscribe and bring your friend to Bat Up with Ola. Share this video. To do.